Good morning. It's a great day here at Elville and Associates, and welcome to today's educational webinar presentation titled Trustee Selection and How to Choose the Right One for You, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director here at Elville and Associates, and I'll be your moderator for today. This is a topic we offer every quarter due to its importance in the planning process. We appreciate those that are here for the first time and our frequent attendees that come back over and over again as part of our Elville webinar series. You've come to the right place for high-level legal education. We encourage your general questions today, so please note them in the questions panel on your screen, and we will pause periodically throughout the presentation to address them. As always, your questions really add a lot of value. They help others learn, so don't be shy in posing your questions anytime to Steve. You also received the presentation slides by email from me yesterday to take notes on them if you wish. They're also available in the section marked handouts on your screen to download at this time. For our professionals on today's webinar, a warm welcome as well. 1.5 continuing education hours are available for most professionals that are on today's presentation. So if you'd like a certificate of attendance or want to have your hours submitted to the Certified Board of Planners, the CFP Board of Standards, please provide that information to me today if I don't have it already, and I'll submit hours for approval tomorrow. You'll also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a minute or two to fill out this very brief survey to offer us your feedback about the presentation. We have some new presentations that are coming up at the beginning of the year next year in 2024, which is hard to believe we're already there, and they're a direct result of your feedback from these surveys, so thank you for your attention to this. Here at Elville & Associates, we always want to be a resource to you and your family for your planning needs. So if you have any new planning needs to address, have old documents that need to be reviewed, or any other matter for that matter, please give us a call or contact us for a consultation after today's presentation, and we'll be happy to be a resource to you. Consultations are always a great way to have your specific questions answered, have Steve understand your situation, and work to create some solutions for you and get a path forward. So I'd like to offer Steve and the firm a very brief overview and an introduction before we get started, and then we'll jump into the presentation. So you should be able to see my screen now as I just click the right button here. Elville & Associates, we were founded in 2010 in Columbia by Steve Elville. We have several different practice areas that we offer here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members, and 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates, as many of you already know. We do that in several ways: through our planning processes with our clients, through educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind every day with every client here at Elville & Associates. Just a bit about Steve. His work as an attorney for the past 20 plus years, 23 to be exact, has been centered in elder law, special needs planning, and estate planning. A member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. He also had a feature story written about him in a National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I've been privileged to be the executive director of since its inception. So if you'd like to learn how we work to make a musical difference in the lives of children each day, please feel free to reach out to me, and I would love to share our story with you. But as always for today, we have a little bit more to discuss than our charity, and that includes trustee selection and that important process. We want to start with a brief poll to learn a little bit about what's brought you here today. And that poll is, what has brought you to today's webinar? Please select the response that applies to your current situation. And your choices are, if I can get to launch, there we go. Number one, I'm a grantor. I've established a trust before. Second, I've been a trustee or am a trustee of a trust. Third, I'm the beneficiary of a trust. Fourth, I'm considering establishing a trust. Or last but not least, I'm an advisor here to learn to better serve my clients. While you're making your choice, I wanted to share an interesting fact that came out from caring.com about estate planning. I thought you might find interesting. Only 34% of adults in the United States currently have a will. And when asked what would get those without a will to create one, the most popular response, 41% of people said a health crisis, which you may or may not find shocking. The second most popular response, 25% said nothing would make me create a will. I found that even more shocking. So don't be one of those people if you are on today's presentation. I think you all are many of the smart people that probably have something in place already and here to learn about trustee selection and that important process in the planning process. So let's see what our choices are. It looks like we're a little delayed in getting that poll started. I apologize. We'll give it another 20 or 30 seconds here.
34%, Jeff.
34%, Steve. A lot of other interesting information in that poll by caring.com that may or may not shock you. We'll give another 10 seconds so we can get started here. So we have 18% say I'm a grantor, I've established a trust before. 17% say I've been or am a trustee of a trust. 0% say I'm the beneficiary of a trust. 46% say I'm considering establishing a trust. And 8% say I'm an advisor here to learn to better serve my clients. So thanks for your patience in that poll. And Steve, I'll make you the presenter.
Thank you, sir. I will get my slideshow started. Show my screen, if you can see it. And Jeff, I'm just going to get that slideshow started. Yep. And thank you, everyone. Good morning. And I'm Steve Elville, principal of Elville & Associates, and it's a Wednesday morning. And where I'm at, down in Southwest Florida this morning, it is very rainy and overcast, but at least it's mild weather. And I understand it's a little cooler in Maryland. And I thank you for being here on your Wednesday morning. We know you're very busy. And it's my favorite time of year coming up, Thanksgiving. It's my favorite holiday. I don't know about you. So I know many of you have family, you're entertaining, or you're being thankful for things in your life. Some of you are going through more difficult times than others, and our thoughts are with you. Many of you who are on this webinar have specific questions about, administration of trusts and how to make sure you're making the right selection. So these are very, very important issues at a very, very important time of year. So it's my privilege to be with you. I want to thank Jeff for all that he does as our longtime moderator and colleague at Elville & Associates. And we have 6 attorneys at Elville & Associates, 3 special counsel attorneys, and a total of about 20 employees. And without them, I could not do what I do. So I thank them, and I thank you for your support of our webinar series, which so many of you have been so gracious to support and say very kind things. So we want to make sure we deliver this morning on substance and education. So as we get into this material, I just want to kind of set the stage, which many of you know that I will do if you've watched a webinar before. And we're going to be intentionally redundant about certain facts and how we describe things so that we drive home the information. But the thing to remember as we start talking about trustee selection is we kind of have to know the lay of the land about trusts to some degree. Some of you know this and some of you don't. So we want to make sure that we lay a little bit of a foundation about trusts as we think in terms of who should be the trustees, or if we are the trustees ourselves or our children are going to be trustees, we want to make sure that our fiduciaries are, meaning our trustees, are well informed. So this is not just a matter of selection, it's a matter of understanding the foundation, and it's also the understanding roles. Sometimes we are trustees during our lives of our own trust. Sometimes we are trustees at the death of someone else, and we are the fiduciary responsible for that trust. And other times we are trustees that are administering a trust after someone dies in the early phases of let's say, a revocable trust that has now become irrevocable after someone has passed away, and we are administering that trust initially to get it distributed to the beneficiaries. So there are various aspects and roles. So we're going to get started here. The other thing I just wanted to point out about what Jeff mentioned earlier that has nothing to do with trustee selection. Jeff, when you said 34%, I was shocked because it's common knowledge, I guess, up until the time that article came out, that in the United States, about 45% of people, generally speaking, have planning. So if those numbers are accurate, it sounds like the average planning percentage, meaning people who actually do planning, has actually dropped to maybe about 34%. So that's a pretty amazing statistic. So thank you for sharing that. All right, well, we're going to get started here. And of course, this is not meant to be legal advice. This is educational. This is high level. We don't have an attorney-client relationship here on this webinar, but we could establish one, of course, if we need further counseling and so forth. So this is high-level education. We'll do our very best to answer questions as those come up. Jeff is a very good moderator, and he will interrupt me at times and let me know if there's a question. And we want to be, again, as educational and give you substance that you could walk away from today, knowing what the lay of the land, the foundation is about trusts in general, and how to think in terms of trustee selection. So we're going to talk about a trustee and what their responsibilities are. And those are a lot, as some of you may know. We're going to talk about the types of trustees, the advantages and disadvantages of these types of trustees. We're going to talk about the perfect trustee and how we would set a very high benchmark for someone like that. We're going to talk about why trustee selection is so important here at the latter portion of 2023. We're going to talk about trustee succession, and the design of the plan. So as we're designing a plan, or we're stepping into the role of trustee when someone else has already designed the plan, we have to kind of understand how that plan was designed and what our responsibilities are. We're going to talk about the various roles of a trustee and wills and trusts. And this is, again, laying groundwork as we go. And we're going to talk about the reasons to maybe consider appointing an independent corporate trustee in some circumstances. And then why should you be concerned about trustee risk, successor trustee risk, which I know many of you in the background are really concerned about this. How can we ensure that our trustees are going to be there for us in the future? What happens if the people we've appointed or the organization that I've appointed is no longer willing to serve or doesn't serve? So this is the risk that we're talking about. Okay, so we're getting ready to go into the trustee role and what their responsibilities are. But I want to take about 60 seconds, and I'm going to set my timer right here. And I want you to be thinking about what has brought you here to this webinar today. It's really good to be intentional. And if you have a pad of paper, a tablet, your phone, whatever it may be, I want you to just make a couple of notes to yourself to get the most out of this. What is my real concern about being a trustee, trustee succession, trustee selection? Do I have questions about roles? Am I serving as a trustee right now and have specific questions? Take just a few seconds here to get situated, get your thoughts around why are you here today? What is it that you want to get out of this webinar? and we have a lot of things going on in our lives. World events, politics, changes in the laws, family, health. Let's get intentional about what we're getting ready to discuss. We have about 5 more seconds and then we're going to move forward. Okay, so my timer just went off and we're going to get started. What is a trustee and what are their responsibilities? Well, the role of a trustee, obviously, is to administer a trust. But I'm going to talk to you in very fundamental terms. The trust is a private agreement. It's a private agreement is one way to think about it. And the trustee is going to follow the terms and provisions of the trust. It will surprise some of you and not surprise others to find out that many trustees do not follow the terms and provisions of the trust, or maybe don't even understand what those are, or maybe haven't even read the trust. So as we think about who should be our trustee, we really want to get fundamental. Will I have a person who will actually take this serious enough to actually read the trust and understand its terms and provisions? Keep accurate records. This goes without saying. This is accounting to the beneficiaries. The beneficiaries have the right to information in this day and time. Make sure the distributions, whether they're mandatory or discretionary, are made according to the what? Terms and provisions of the trust. Make trust investments, okay? We have to have assets prudently invested. So the trustee has to be understanding how to do that and work with professionals 99% of the time, in my opinion, to do that. The trustee has to communicate with the beneficiaries who are entitled to communications and information. Ensure that tax filings are complete. This is an area of understanding in and of itself. And manage the assets, taking into consideration the income taxation of trusts. And that subject is above and beyond today's discussion, but that's something that you should have a fundamental understanding of. So let's talk about trust basics. So I talked about just a minute ago, a trust kind of being a private agreement. So a trust is a relationship, as according to this definition here, and it springs from this agreement that I just mentioned, where there is a grantor, and in the old days, this used to be called donor or trustor, and so forth. This now terminology is, modern terminology is grantor. It's all the same thing. And this is the person who creates the trust and could be the trustee of their own trust, like some of you may be for your own revocable trust, or this is a grantor that's creating a trust where there will be other trustees for the benefit of a beneficiary. So the roles and responsibilities of the trustee are generally prescribed in the trust agreement, but not really. Sometimes those responsibilities are not 100% described, and they're more assumed that the trustee has this fiduciary role under applicable trust law. So we just talked about the settlor or the trustor or the donor, and that's the terminology for the modern term grantor, the person who is establishing the trust. The trustee is the person who is taking charge of the trust property. The other day, I assumed the role of a trustee for someone, and I had to not only acknowledge it, but I had to accept that I was the trustee, and I have to accept the trust property that I will now control and basically manage for the benefit of the beneficiary. So that's what the trustee is doing. They are accepting the property. And the beneficiary, although we assume we know what that is, let's just get definite here, is the person or persons that the trust benefits. This person is to receive income or principal, either mandatorily or not, for their benefit. Now, a revocable trust, as some of you already well know, is nothing more than a substitute for a will. So a revocable trust is not magical. It is not mysterious, although it sounds like it to some people. It is simply an alternative. So if you were to come to an attorney and say, well, I want a will, okay, well, what if we didn't have a will? Well, we'd have to have a substitute for a will. And why would we have a substitute for a will? Well, a person would want a substitute for a will if they wanted to avoid probate, have a private management tool, okay? And there are some other nuanced reasons to have a revocable trust, but mainly it is a tool to avoid probate. Does a revocable trust protect from taxes? No. Does a revocable trust protect from creditors? The answer is no. So a revocable trust is simply an extension of the grantor. It is a substitute or alternative to a will. Now, an irrevocable trust generally cannot be amended, whereas a revocable trust can be amended or modified at any time. But an irrevocable trust is generally something that's more permanent. It generally is not modified, but nowadays, an irrevocable trust can be modified under many circumstances through judicial means and other laws that have been passed to allow this. It also can be amended through what is called a trust protector, which is a special fiduciary. So an irrevocable trust can be a trust that stands alone during your lifetime or someone's lifetime, or it can be a trust that is created at death. For many people, this gets very confusing about the difference between a revocable and irrevocable trust. I would just simply describe it as this for simple purposes for today. A revocable trust is a fancy will, so to speak. It's not a will, but in other words, it's just a substitute for a will. An irrevocable trust, I would like you to think about this as a trust that is established for a special purpose. This could be a life insurance trust. It could be a charitable trust. It could be a residence trust. It could be a special needs trust that's irrevocable. Things that are established for a special purpose. Or it could be a trust established at death that is created under a will or trust. So traditionally, again, a revocable trust is for property management, avoidance of probate. Let's say someone has a property in a certain state, but that's their home state, such as Maryland. And let's say they have another property in Delaware or another state. Well, a revocable trust is many times used to avoid probate in Maryland or whatever that home state is, plus the out-of-state property avoids probate as well, if that trust is properly funded. But there is a little bit of an increased cost to establish a revocable trust generally. And again, that's an alternative to a will. But there are also special purpose trusts, such as the ones I just described. This could be a trust for a minor. This could be a trust for an at-risk beneficiary, someone who can't really take care of themselves or make good decisions, or they have substance abuse issues, and on and on. We know that we are dealing with situations like that today and have always dealt with them. Or it could be a trust that's in perpetuity. And some of these trusts for at-risk beneficiaries can also be trusts for long-term purposes, bloodline trust, or trusts that last forever in a certain fashion called a perpetual or a generation skipping trust. Now, there are trusts that are established for beneficiaries for the long term. These trusts can be established under a will or a revocable trust. These are those trusts at death that I was just talking about. The beneficiary can be, in some states, such as Maryland, they can be the trustee and the beneficiary of the trust. So as long as assets remain in trust, the beneficiaries are protected from most creditors, but not all creditors. There are exception creditors, such as those that can get to the trust for purposes of alimony that wasn't paid, or child support that wasn't paid, or IRS is not paid. So these trusts do not protect against all potential creditors, but most. And this is going to mean that, well, the beneficiary could be the trustee of their trust, but maybe they shouldn't be. So as we think about who should be a trustee of a trust, and as we try to lay the groundwork for what trusts really are and how they work, you're going to be thinking, those of you that are establishing trusts for a child or another beneficiary, should I appoint that child as the trustee of their own trust? Well, the short answer is you can, and they will have what we might call a moderate level of asset protection. But trustees that are independent, such as people that are unrelated to the beneficiary, people that are unrelated to you, people that are independent, or independent corporate trustees, let's say, versus and independent individual trustees. These people and these corporations that are more independent are going to provide, for various reasons, greater asset protection to the beneficiary, much greater. So this is going to be part of your thought process as you think about who trustees should be. There are supplemental needs trusts and special needs trusts. These come in different varieties, and these can be revocable or irrevocable depending on what the situation is. To describe this briefly, a third-party supplemental needs trust, which is a mouthful, that is the bread and butter of special needs planning. So if someone has a loved one with disabilities or someone who needs to protect their means-tested benefits should you pass away, and you or other people in the family leave assets to that person, the third-party supplemental needs trust is the trust you're going to want to see established, either in the will or revocable trust can establish this inside of those vehicles, or establish that special needs or supplemental needs trust on its own. The first party supplemental needs trust, which you'll see here in this slide, which is called the self-settled trust, that trust is the kind of trust that we call a first party trust, where the individual receives funds in their own name, that person with disabilities, that they really should not have in their own name. And the government provides for a couple of different options to put that money into a pooled trust, P-O-O-L-E-D, pooled trust, or into what is called a first party D4A trust. So that is for the person who receives an inheritance that has disabilities that they shouldn't have received, or they have an automobile accident or some kind of birth injury. That kind of self-settled trust is what we need to create for that person to get the money out of their name. So again, just to reiterate and to be intentionally redundant to drive home the information today, a trustee is a person who accepts the property that is placed in trust and manages that property as directed by the grantor, the person who established the trust, for the benefit of a beneficiary. And that person is the person who benefits from the trust and receives distributions. And how can distributions be made as you're thinking through who my trustee should be? Remember that a trustee's job is to make distributions either to the beneficiary, meaning distributing money directly to them, or distributing money for the benefit of that person, making payments. A good example for this is a person who is a beneficiary of a trust needs a new computer. So the question is, should we distribute $2,000 or whatever the cost may be? Should we distribute $2,000 directly to the beneficiary, or should we buy the computer and give the computer to the beneficiary, or order the computer? So there is a distribution to the person or for the benefit of a person. Let's spend just a second talking about grantor versus non-grantor trusts. But before I do that, I'm going to take about 60 seconds here again. Let's stop and go to our pads of paper or our tablets, and let's just ask ourselves, do we have any questions at this point? Is there any point of confusion? Has there been a question that you've had in your mind for many years that you, or just recently, that you need to have answered? Are you confused at all about the different types of trusts, revocable versus irrevocable? Whatever it may be, let's take another 35 seconds or so and just see, do you have anything on your mind now that you need clarification about, or you just need to make further notes? And we're at about 15 more seconds on this. All right, 5 more seconds. All right, thank you. And Jeff, you let me know if anyone has any questions. I know you'll interrupt me.
We do actually, Steve. Can I pause
Go
for
right
a couple minutes and pose this to you? Thank you. So first question and second question is, can an LP instead of a corporation become a trustee? And also, can an LP instead of a natural person be a beneficiary?
Well, thank you for that. That's a very interesting question. And I don't have the 99% or 100% answer on that, but off the top of my head, I would say I've never seen that. And I do not think so. I do not think that could be realistically done. Um, and I have not seen that in my experience. That was a great question about what I think you're saying is a limited partnership.
Okay, next question is, if one has limited assets besides financial accounts that have beneficiaries, home, car, bank, and credit union accounts, one has a will upon death, and you do not have a trust, would all of your assets be publicly available, including sizable financial accounts with Fidelity brokerage?
Well, thank you for that. And I'm going to extrapolate just in the quickest possible time what I think you're saying in that very nice question and very broad question, actually, at the same time. What I'm gathering from that question is if I have a will and I don't leave trusts for beneficiaries, and I'm going to assume that the beneficiaries under your will are adults, and I'm going to assume that they do not have any kind of disabilities or special needs. Well, it's perfectly fine to leave things outright. So when we pass away under a will or a revocable trust, we can leave assets in further trust for beneficiaries for various reasons, which is what this webinar is about, or we could leave assets outright and free of trust. So if you don't have a strong desire to protect beneficiaries to give them asset protection or to do spousal planning in trust and all of the features of a trust, then it's perfectly fine to keep things very, very simple and leave assets outright. Now, what you're going to find, if I extrapolate from what I think you're asking, if you use a will and you have substantial assets at your broker, that are non-retirement assets, which I think you were saying, then those non-retirement assets are going to go through probate if they are in the sole name of the survivor, or if you're the survivor, and then they will go through the probate process in a state like Maryland, where I practice. So it would seem that if someone has a large amount of brokerage assets that are going to go through probate, then a revocable trust might be the better vehicle to give privacy and also non-probate treatment to those large non-retirement assets that will pass upon your death or upon the death of both of you if you're married. But we certainly could keep it simple and leave those assets outright and free of trust. But in probate, they will go through a process, which is usually about 9 months. And in trust administration on a private trust, like a revocable trust, there will be a period of administration, but generally speaking, the cost would be less, generally speaking, by using a revocable trust if you have a lot of non-retirement assets.
Okay, thank you. And next question we have is, if one is the sole trustee of an irrevocable trust, can a second trustee be added, being afraid of the first trustee's death?
Yes, I thank you for that wonderful question. I think, yes, that can be done. It can be practically done in most circumstances, but hopefully the trust that was established for you, that gave you this irrevocable trust and for your benefit, hopefully the trust that established that is a flexible vehicle that has some modern amenities in that document that provide for the ability to have a second trustee appointed and so forth. So there are many ways to get that done. And the first thing we would want to do is look at the current document that established your irrevocable trust to see if there is a simple way to establish a co-trustee with you or a successor trustee if something were to happen to the current trustee.
Okay, and then last one for now, if that's okay. What do you recommend for someone who wants to set up a special needs trust for their child who has special needs but doesn't have any family or friends who would make suitable trustees?
Well, thank you for that question. And this is one of the greatest challenges for parents with a child with disabilities today is who will be the fiduciaries, who will be the advocates, who will be there for my child when I'm no longer here. So this is especially exacerbated when there are no family members. So I think this is a very careful design discussion. I think that when you sit with your attorney and you say, this is my situation, and we are designing a special needs plan, which is part of your regular estate plan as well, I think there's a special emphasis in your case about design. Who can we engage now in the, depending on the age of your child with disabilities, who can we engage and start the process of designing this succession of how this is going to be handled. And my thought, just not knowing you, but thinking about what you're saying, is perhaps you would have to have, by necessity, a corporate fiduciary or an independent trustee of some kind, individual or corporate, and that individual trustee or corporate trustee would need to engage professionals that would be able to assist with advocacy and caregiving and all of the support systems that your child will need. So this is going to be a matter of designing the trust, but also designing the future fiduciaries and building flexibility in there as well.
Okay, thank you, Steve.
Thank you very much. And everyone, we know this is a lot of information, so thank you for hanging in there with me and for those wonderful questions. We're going to cover this very quickly. As we think about trusts, trusts are taxed a certain way. So let's go with the most simple example. Let's say you have a will and you are, a person who has a power of attorney, an advance directive, and a will. Well, obviously, you're a U.S. taxpayer and you are filing your Form 1040 every year. But now one day you say, well, gosh, I would like to avoid probate, or I have another property in another state and I don't want that to go through probate. I want the advantages of a revocable trust. So you switch from a will-based plan to a revocable trust-based plan. Well, when you did that, you may or may not know this, but your trust, your revocable trust, is nothing more than a substitute for a will, and that revocable trust is taxed under your Social Security number, just as if you had no will, just as if you had no trust. So where I'm going with that is, if you create a revocable trust, that trust is a grantor trust. A grantor trust is simply a fancy term that says you pay the tax just like you always have for your assets. You just happen to have a trust. So think about this. Uncle Sam would look at your trust and actually just ignore it, because your trust, your revocable trust, is identified by your Social Security number. You pay the tax. Well, there are non-grantor trusts as well. And a good example is the example we just gave a few minutes ago, where someone dies with a will or revocable trust. Someone dies and they leave a long-term irrevocable trust or an irrevocable trust of some kind for a beneficiary. That trust is a non-grantor trust. That trust is going to pay its own tax. So there are basic trusts like revocable trusts that are grantor trusts. The grantor pays the tax. There are advanced trusts like irrevocable life insurance trusts and other types of trusts where those are created as grantor trusts as well. A good example would be a gifting trust. A grandparent or a parent creates a gifting trust for a child or grandchild, funds that trust, but they want to continue to pay the income tax themselves as a further gift to the grandchild. That is a grantor trust, whereas a trust at death or other trusts that are created during lifetime would be considered non-grantor trusts. They pay their own tax. So don't get too worried about this for today, but just understand as you're selecting trustees, we're going to need to understand, are we creating a grantor trust, or are we talking about a trustee for a non-grantor trust, where that trust is going to have to pay its own income tax, file a 1041 perhaps, which is a fiduciary tax return, and our trustee is going to have to understand the fundamentals of income taxation of trusts. Now let's talk about the Maryland Trust Act. So the Maryland Trust Act came out in 2014. It was quite a big deal. It brought Maryland up to speed with other states, but it also put Maryland ahead of certain other states. It started to talk about things that were talked about on the national level for quite some time. A qualified beneficiary. So this person is a person who's an adult over a certain age, and when they get their distribution, or when someone dies and they have a share, they are entitled to information. So they have to be provided with notice. They have to be provided with the information that they are entitled to by law. And surprisingly, this was not known this was not done, I should say, prior to 2014. Beneficiaries of trusts in Maryland were not necessarily entitled to notice and information. So this is a very big deal. And you'll notice there at the bottom, there is no such thing as a quiet trust in Maryland. There are some quiet trust laws in other states like Delaware, but in Maryland, we do not have the ability to hold back information from beneficiaries, and this can be a good or bad thing depending on the situation. Beneficiaries have, again, they're entitled to information, they're entitled to a copy of the trust. What we don't want is we don't want for our trustee to not be aware of this. We don't want our trustee to violate these rules of notice and information, and they are exposing themselves to breach of fiduciary duty, meaning they have not carried out their responsibility, and this could be grounds to have them removed as a trustee. So we want to have a trustee that understands the fundamentals of taxation. They need to understand the fundamentals of what the documents actually say, why they are being managed, why the assets are being managed for the beneficiary, what the beneficiary's needs are. They also need to understand their reporting responsibilities and their notice and information responsibilities towards the beneficiary. Now, as we continue to move on here, it's 20 till 11, we're doing okay. Let's talk about the financial advisor and their role in the trust establishment and in the trust administration. So if you're not familiar, I'm a big believer, and all of us at Elville Associates are big believers in working with our financial advisor colleagues as part of a collaborative team. But needless to say, that's very important. But let's step back for this for a second, and let's talk about what a trustee's job is as far as assets and assets under management and investments. Well, every trustee, in my opinion, should engage a financial advisor unless the trustee themselves is a professional advisor, financial advisor. And even then, I think they should be very careful about investing the trust assets. But let's say that the trustee is doing their due diligence, they're carrying out their responsibility. What would they do, in my opinion? Well, they would engage a financial advisor or financial advisory firm that understands what? That they, the trustee, are a fiduciary. They are a fiduciary. They have a very high level of responsibility to make sure the trust assets are administered properly and invested properly as a prudent person would. So financial advisors are holding, in many cases, and banks and other institutions, tremendous amounts of money that are either held in the revocable trust or they're going to be held in the irrevocable trust after someone dies. So we want to make sure that we get, if we're a trustee or if we're appointing a new trustee, we want to make sure that person gets an investment policy statement. An investment policy statement from that financial advisory firm saying that they understand that the trustee is entrusting them to invest the money, and they have a fiduciary responsibility to invest the funds at a very high level as a fiduciary in accordance with the best allocation for the trust itself and the beneficiary. All right, so that just goes without saying. I wanted to make sure that you understand that this is one of the fiduciary responsibilities of a trustee. But here, what we're really talking about is when a trust is created, what is the role of the financial advisor? Well, obviously they have a big role, and the trustee needs to work with them, and the financial advisor works with the trustee to establish the trust. So let's say someone dies and a trust needs to be established for a beneficiary. We're going to make sure that gets established with a proper tax ID number. We're going to be setting up accounts properly with the trust company or the financial advisor in this case, making sure there are checkbooks available, making sure there's cash available for distributions, that not all the assets are tied up in investments, that a certain amount of assets are available for the needs of the beneficiary. The new financial advisor relationship with the trustee is going to make sure the trust funds are allocated properly. We've seen many cases where there is a trustee who is not investing according to the right allocations based on the goals of the trust and the beneficiary's age. So these are basic things that the financial advisor is very important, is going to help the trustee with. And as you see at the bottom, when someone dies, making sure the non-retirement assets get a cost basis adjustment or receive a stepped up basis at the death of the person. So we need to look at this as trustees or our future trustees and say, is this portfolio properly allocated? Is it supposed to be geared toward income? Is it principal growth? What is the goal here? Is this trust established and invested properly? Is this trust too heavily weighted in one particular type of investment? So we have to be concerned about this with the collaborative relationship between a trustee, the financial advisor, and the CPA. And of course, an attorney may be in there to advise as well. Now, Jeff didn't do this, and he is still looking. He told me he's looking for photos of the perfect individuals. And I told him to look really hard, maybe even go to Hollywood to find somebody who looks perfect. But we don't have any photos up here, but if we did, in all seriousness, we're trying to find the perfect person. Who is this trustee that's perfect? This person is going to advocate for the beneficiary if it's necessary, if a person has disabilities. But down here in this lower left concentric circle, this person is keeping accurate records, keeping the beneficiary informed, making sure the trust is in compliance with duties. On the financial side, making sure that investments are proper. We just talked about that. Making sure the trustee understands that they can hire professionals, making sure they understand tax-related issues for trusts. So all of these things and these concentric circles kind of add up to, this is kind of the perfect person or the perfect corporation that's going to act as trustee. So we want to make sure that this is the benchmark, this is the high benchmark that we're setting. And this is a baseline for you to work from. So why is the trustee selection process so important? Well, let's talk about this. Trust can last forever now. So there used to be something called the rule against perpetuities in the Old English law, that trust could not last more than a certain period of time. And why was that? Because the government did not want people to accumulate dynasties. Well, this has been largely abolished in most states. It's been abolished in Maryland since the early 2000s. Trust can now last forever. So forever is a long time. So we want to make sure that we are putting a process in place or tiers in place of trustees. And I'm going to get back to the statistic that Jeff was giving earlier on, that 34% of people in this country actually have planning, okay? Now, what in the world does that have to do with trustee selection and the fact that trust can last forever? Well, let's take those 34%. If I had to guess, those 34% did a great job. That's about a third of Americans, is lower than we anticipated. But how many of those 34%, or let's say it was even as high as 45%, how many of those people actually keep their trusts updated? How many people keep their documents updated? Well, if you don't keep your documents updated, bad things can happen, right? Your documents get outdated. They don't keep up with changes in the laws and all of those things. But what does this have to do with trustee selection? Your trustees continue to get older. Your trustees continue to have family issues and they have health issues and so forth. So we want to make sure that as we think about trustee selection, that it is not just for today. Trustee selection is about updating our documents over a period of time so that you can have peace of mind that when you do pass away, or if you're a trustee of a trust that's already been established, like a person said on the webinar here just a few minutes ago, we want to see if we can get some successor trustees appointed. But if you're still in control of your own trustee selection process, you want to make sure you're updating your documents over time so that when you pass away, you have a good set of trustees already in place in your documents, but also that you've provided for the flexibility that the trustees can further be appointed through something called a trust protector, which we're going to talk about later. I am going to take just a second here because I've just been given a notice by my computer that I need to plug my power in. So bear with me just a moment. Thank you. I apologize. I didn't realize that was the case. Now, the second reason we need to make sure that we're thinking about trustees is that trusts are more portable than ever. Trusts can be moved among different states. States are in competition for trusts. Beneficiaries are changing their domicile. Many of you have children that are successful or living in different states, or they've gotten married and moved away. When we pass away, our loved ones could be living in different states other than where we think they're living now. Trustees have options. They could resign. They could refuse to serve. So that's a big factor. We want to put our trustees in place, do the very best we can today, but we want to understand that that could change tomorrow based on where our trustees are mentally, whether they will continue to agree to serve. I had a case in the last 2 years where someone needed their trustee to step in. I was a trust protector. I tried to facilitate the next trustee to step into the role they were supposed to step into, and they could not serve. There were circumstances where they refused to serve. So we have to build in flexibility. Decanting. Decanting is something that Maryland now has a new decanting law, and Jeff and I are going to do a webinar soon about the new Maryland decanting law. But decanting basically is one of those techniques to be able to change a trust. Not only change a trust by amending it, but to change the trust by creating a brand new trust. So decanting could change the landscape of a trust, and it's kind of something you need to get your minds around, not to worry about, but to understand that it's out there. And if that were to happen, trustee selection and who we're putting in charge of these trusts is very important. And of course, as I mentioned several times in the last few minutes, flexibility for changing circumstances. I'm going to take another 60 seconds, ask if anyone has any questions, see if you have some notes you want to take, epiphanies that you've had. Jeff, I'm going to start the timer.
We do have a few questions here. Can we pause for that right now, Steve?
Sure, go right ahead.
Absolutely. Thank you so much. Trying to find the right time to do that. This is a good time. So first question we have is, can you touch briefly on the trust protector?
All right, thank you. So in 2014, Maryland recognized something called the trust advisor, but nationally, this has always been known as the trust protector. So to my mind, these are basically the same roles, but a trust advisor / trust protector is a special fiduciary. So in the past, I would like you to kind of imagine that there are millions and millions of trusts out there, and today there's millions and millions of trusts. And these trusts largely are static. These trusts cannot be changed except by judicial measures or other techniques. But a trust protector is a flexibility mechanism where the world of the IRS, the world of trusts and estates, recognizes the existence of a third person, a third party, and that person is a person who has flexibility to make adjustments. And those adjustments have to do with amending a trust administratively, directing the trustee to do something administrative, such as there have been changes in the laws, changes in the tax laws. So the trust protector is going to amend that trust to be more in conformity with the law. A good example would be the Secure Act. Let's say someone had a special needs trust or supplemental needs trust, and now the Secure Act continues to change. Hopefully it won't. And let's say a change needed to be made to that supplemental needs trust. Well, a trust protector could make that change. But perhaps more importantly, a trust protector has the power to remove and replace trustees. So let's pretend, as we're thinking through the trustee selection process, let's pretend that you've selected a trustee. That trustee is either inappropriate when the time comes, or that trustee refuses to serve. That trustee could be removed and replaced under various circumstances. So a trust protector can be given many special powers, but generally the two major powers of a trust protector are to remove and replace trustees or to make administrative changes to the trust. So that's what a trust protector is. And I would highly recommend that most people have a trust protector if for no other reason than to build in flexibility. It's not for everybody. It takes a little bit of time to get your mind around the concept, but it is designed for flexibility. And I think in today's world, flexibility is the key.
Okay. Is the term executor appropriate to use as someone who assumes ownership of a trust when both husband and wife are deceased and then executes the plan for distribution of the assets?
Yes, thank you for that. I think executor is not an appropriate term for that particular thing. I think the executor is an appropriate term to be interchanged with the word personal representative, which is what Maryland uses, for the person who is your fiduciary to administer your will, your probate estate after your death. But the appropriate term for a person who administers a trust estate, if you want to think about it like that, is a trustee. But that's a great question. An executor is really synonymous with a personal representative of an estate.
Next is, what if a TOD has been filed for a brokerage account? Doesn't that avoid probate?
Yes, so a TOD or transferable in death account does avoid probate. And if that were the case at your death, then the assets flow to the beneficiary of the TOD, the transferable in death beneficiary, with no probate.
Okay. And one or two more, if that's all right.
Yes.
If the grantor transfers his personal residence to a MAPT and continues to pay the mortgage, are those mortgage payments deemed income to the MAPT?
Well, that's a great question. So it's a little bit all beyond the subject of today's presentation, but I think what you're referring to is a Medicaid Asset Protection Trust, which is a very powerful tool today that's used in elder law to protect assets from Medicaid spend down and to preserve assets in long-term care situations. So I think the question is, if I have transferred a house to the Medicaid Asset Protection Trust, I continue to live in it, and I continue to pay the mortgage payments, is that income to the trust? Well, I don't think so. I think there are very esoteric nuances of a Medicaid Asset Protection Trust, but to my knowledge, this is not considered an income as far as we're concerned in Maryland, as far as planning and elder law.
Okay, and one more for now. Does the trustee have to provide a copy of the trust to the beneficiary before the death of the grantor, or can the trustee provide the copy after the grantor's death?
That's a great question. I think in general, not knowing your particular situation, the answer would be there is no requirement that somebody's trust or will ever be given to a beneficiary prior to that person's death. There may be certain agreements that are entered into in families, and maybe there's been a dispute in the family, but generally speaking, they would not be entitled to anything until the time of your death.
Okay, thank you. Thank you for the good questions.
Thank you, everyone. Thank you, Jeff. So as we think about the trustee selection process, then, this could be very easy for you. You may already have a mental checklist, children, siblings, other relatives of yours. You may have a special relationship with your financial advisory firm, and they may have a corporate arm that is an independent trustee. You may also want your attorney or your CPA to be the trustee. So you may already have this mental checklist. But we want to think in terms of, and I alluded to this early on, we want to think in terms of what kind of trustee are we looking for? Are we looking for an interested trustee? Remember, we talked about your child or the beneficiary themselves, if it was a child or others, they can be the trustee of their own trust under Maryland law. But is that a good thing? Is that something that's okay? For many people, it is. And for many people seeking greater asset protection, or perhaps that beneficiary should never be the trustee of their own trust for various reasons, we may want to use an independent individual trustee or an independent corporate trustee. So all of this design is best done kind of in a review session or sessions where we spend lots of time diagramming and talking and speaking with your advisory team, your CPAs, your financial advisors. Maybe this is done collaboratively at times, maybe not. This is a design issue. This is a discussion issue. Conflicts, we have to think about who the trustees are and are they going to work together? Are other siblings, for example, in conflict with some of our potential trustees? We have to think through these things. We just talked about this next bullet point, independent individual trustees versus corporate trustees, advantages and disadvantages. One of the things that's happening right now, as far as I'm concerned, is that there's a lot of competition for trustee business in the independent trustee world. Lots of people are vying, lots of companies are vying for your business, and they are charging very low trustee fees because they want to keep assets under management throughout your lifetime. They want to keep assets under management after your lifetime for children and grandchildren who will have further trusts. So it's a wonderful time, in my opinion, to be looking at trustee selection because there's so many trustees to choose from, so many different kinds of trustees. It's daunting. It can be daunting if you don't already have that mental checklist, but I can assure you that if you're willing to engage in a discussion, I promise you that you will have epiphanies of what is best and how to design things. We talked about the trust protector just a few moments ago because someone asked about this kind of thing. This is a wonderful special fiduciary tool that is not right for everybody, but I would say for most people, trusts, especially trusts that are going to last a long time in perpetuity, you will want to build a flexibility for the trust protector in that document. Special needs trusts absolutely should have trust protectors in most cases, but you're going to see, if you haven't already, that in the modern planning world, trust protectors are going to be used quite a bit, and I think are generally a very good idea for flexibility. Now, we talked about interested trustees versus independent trustees. Why is this such a big deal? Well, it's very difficult to describe in this brief webinar, but there are different standards of distribution, different points of view, different levels of oversight. So to make a long story short, let's say that a child were the trustee of his or her own trust. They would have to participate in the management of that trust by distributing to themselves, for what many of you have already heard about for years, health, education, maintenance, and support. This is what they generally will do for various tax reasons, for various trust design reasons and IRS reasons. Well, if there's an independent trustee, that independent trustee does not have to distribute for that traditional ascertainable standard. That independent trustee can distribute for any reason, and because of that, although it's an oversimplification, in addition to a trust protector, in addition to the proper structure of the trust, in addition to what I would say the spendthrift provision of the trust that actually creates this envelope of asset protection, the independent trustee will provide much more asset protection for the beneficiary. So these are the practical considerations, whether there should be an interested or an independent trustee. And we did talk about this, but I'm now going to go over again, be redundant about the trust protector. Remember, the trust protector is a special fiduciary. It's been around in Maryland since 2014, although we used at our practice trust protectors over the last 20 years or so because we wanted to be on the leading edge of design. It is basically a power of amendment. So a trust protector can remove and replace trustees, direct the trustee, mediate disputes, amend the trust, compel accountings, and they can be given other advanced powers. So trust protector, a very powerful tool for what? Flexibility. Now, as we begin to wrap up, let's talk about the roles of trustees in various documents. So in a will, we can have very simple outright distribution. We talked about that a few minutes ago, keeping it simple. But where we're talking about trusts, we're talking about trusts under wills. So under a will, there could first be a non-marital trust. We normally call that a bypass trust, Traditionally, this has been called a family trust or a residual trust, or we can have what is called a marital trust. So for spouses, the first role of a trustee is who will be the trustee of a spousal trust, either a non-marital or marital trust. Or let's say we have young beneficiaries of a particular trust. Who will be the trustee for those young beneficiaries? Who will be the trustee of their own trust? We just talked about this. This is a testamentary trust created under a will or a revocable trust. Who will be the trustee of that spendthrift trust? Or we could be serving as a trustee of someone else's spendthrift trust, or it could be a lifetime irrevocable trust that someone created for you or others. And the question is, who is going to be the trustee of that trust? Now, as we look to a revocable trust, which is what? Nothing more than a substitute for a will, we have similar but different roles. So first of all, we have a living trust. So who's going to be the trustee of the living trust, which is nothing more than a substitute for a will? Well, that's going to be you. That is you. And at death, however, we have the same situation we have with wills. Do we have outright distribution where there's no further trust? Or do we have a non-marital trust or a marital trust? These questions say, who is going to be the trustee of that spousal trust? And we have the same situation. Do we have a trust for someone who is young? For example, someone under 30 or 25? Do we have a perpetual trust, a trust that's being established for a child or grandchild that will last forever? That could be that irrevocable spendthrift trust. Or are we talking about being a trustee of someone else's irrevocable spendthrift trust? Corporate trustees, let's talk about this for just a moment. Some of you have wonderful relationships with your financial advisory firms. You want that firm to continue to manage your trust assets after your passing, perhaps. Their experience, their asset management, their objectivity, okay? Their independence. They are arm's length. They are not family members. They are regulated by the state government and the federal government. They must provide a schedule of fees. Generally speaking, there's going to be an element of reliability. They are a referral hub for a lot of information. Generally speaking, they have longevity. This could give you, and does give many people, peace of mind. Now, let's say that you're not inclined to appoint a corporate fiduciary as your primary trustee, which some of you are. You could think about having them as a successor trustee. Now, remember that corporations today can be bought and sold. A good example is the recent merger between SunTrust and BB&T. Things happen. Corporations are sold all the time. So if we have a trust protector, then we can deal with future situations where a corporate trustee that you might have chosen has changed. Their identity, their culture, whatever it may be, has changed, and your trust protector can make a change to the trustee if that trustee is no longer a good trustee for the beneficiary. Why should we be concerned about this successor trustee risk? Well, we talked about this a little bit throughout. The age and experience of trustees. We're all getting older. The health and deterioration of your trustees over time. Now, with this said, I would say in today's world, I'm seeing people being appointed as successor trustees that at an older and older age, people are living a very long time. Many, many people are very highly competent and retired professionals that were, very, very competent in their respective fields. These people can be great successor trustees. So do not discount those individuals. As long as we build in flexibility, in my opinion, we are doing a great job managing future trustee risk. Remember that many trustees, most trustees, serve without bond. So bond could be required, or bond could be something that is not required. It saves a lot of money. And when we're appointing successor trustees, remember, we are generally appointing them to take over without the requirement of bond. So this is why we want to keep our documents updated and think through who the trustees are as we continue to go through our lives, not just one time. Other life changes, divorces, creditors, bankruptcy, the unforeseen. We're going to take that into consideration. We want to be concerned that the future trustees could be disconnected with the beneficiaries. Now, this depends on the type of beneficiary. It depends on how educated we are making our beneficiary, which I strongly recommend that to some degree that you make sure your beneficiary is educated as to who the trust protector is, who their trustee is, where the resources are for them. Demands of the beneficiary. Sometimes beneficiaries can be very demanding, and I know some of you are smiling, some of you are not. But it is possible to have a very demanding beneficiary. So we want to make sure that if a beneficiary is a very high maintenance, very demanding beneficiary, that we have a trustee who's going to stand up to that test and not quit, not resign. And if there is a successor trustee that takes over, that they are willing to step into that role. And that gets to the next bullet point, which is trustee willingness, fortitude, and perseverance, excuse me. And we want to make sure the trustee is willing, that they have the fortitude, and they will persevere under difficult circumstances, although sometimes being a trustee can be a very difficult job. And lastly, trustee compensation. There are basically two standards of compensation. One is statutory compensation, that is prescribed in the law, which is fairly low in Maryland. Most modern trusts are designed where the compensation is reasonable compensation. My trustee can receive reasonable compensation, which is very subjective. And so a professional trustee would hopefully have a schedule of fees. A trustee who is a non-professional, a reasonable compensation is going to be subjective as to what their experience is. It could be $50 to $75 an hour that would be considered reasonable compensation. So this is all part of the discussion and the design of trustees. So as we start to wrap up, and we're on time today, very much on time, thanks to Jeff getting us off to a good start, there is really no way around what I would say is just this discussion, this time to think, which we're going to talk about in just a minute, to be able to sit, be quiet in this busy world, think about the future, think about your goals and desires, because everything is driven by goals, everything in estate planning. A trustee selection, what is my goal? What am I trying to accomplish? There's nothing to fear in these conversations. Any conversation with an attorney like us or an Elville and Associates, there's nothing to fear. There is an attorney-client relationship that is created, even if you do not become a client of our firm or any other firm. You are entitled to attorney-client privilege when you discuss these private things in the presence of an attorney. We would like to review your existing documents if you have them so that we can review them. And generally speaking, we do not charge to review documents, basic documents, and provide an opinion. We would like to help you have an advisory team or meet your advisory team if you already have one. Your financial advisors, your CPAs, we want to work with them. We want to help make sure there are no gaps in this advisory team. And like today, we had wonderful questions. I bet you we had 8 or 10 or 12 questions today. We want you to have your questions answered. If you'll come with questions, we would like to consult with you. We would like to give you the time to think. We at Elville and Associates, we do administer trusts. We have a trademark, our Waypoint Fiduciary Services, where we act as trust protector, we act as trustee. So we want to be here to help and provide trust services, but generally speaking, we want to collaborate with you and help you form the proper approach to trustee selection for your own particular situation and to also be a resource to you. We want you to have the time to think. So Jeff, I think we've done a great job to end by 11:15, and there may be further questions. So I'm going to turn it back to you. I thank everybody for your time and attention, and I wish you a happy Thanksgiving.
There are further questions, Steve. So
Great.
The more that you offer, the more questions that arise, which is great.
That's
So
great.
thank you. Thank you for a great presentation, Steve. Really very helpful and informative. I learned so much when I listened to this presentation for the 15th time over the years. A lot of great information. So now would be your time to get your final questions into Steve, and we will answer those final questions. And then we do have a few here that we're going to run by Steve right now. And then I'll have a couple of final thoughts, and then we'll end on time. And our first question that we have lined up here: can the grantor direct the trustee to remain invested in the real property transferred to the trust?
That is a tremendous question. Thank you for that question. The answer is yes. But I would say that my opinion would be that that is a risky proposition, and I'll tell you why. Most trustees, most corporate trustees, not all, but most, will not want to deal with real estate. So real estate has its own characteristics. It is an asset, again, that most trustees do not want to deal with very well. Not to say that there's not real estate in trusts every day. So when we say you must keep this real estate in trust in perpetuity, we are really tying the trustee's hands. So what I would recommend, if we were to meet, or whatever it's worth today, I would recommend that this is your primary intentions, obviously very clear, very strong intention that you have, and that you provide a memorandum of intent. A memorandum of intent is an informal set of instructions that you provide to your trustee to make sure they understand what your wishes are, your long-term values and goals in the planning. But by doing that, you're guiding the trustee as to where you want them to go, for example, down this road ahead. And you want them to stay on that road. You know, you want that property to remain in the trust, and you want it to be there for various reasons. But there could be changing circumstances in the future. There could be very unfavorable laws in the future, which probably won't happen, but there could be. And my strong advice, if we were to meet and we were in an attorney-client relationship, I would probably advise to not make it so narrow, but to make it where you're creating this lane that you want them to stay in, but you still give them the authority to deviate from that lane if it was absolutely necessary. But that's just my preliminary thought.
Okay. Next, can the trustee choose accrual accounting instead of cash accounting?
That's a great question. I think in trust administration, we are probably looking, I'd have to double check, but I think we're looking at calendar year accounting for the most part. But during the administration of a trust, I think that there can be accrual accounting. So hopefully I haven't messed up that question too much, but please email me offline and I will get you a better answer to that question.
Okay. What is the relationship between a marital trust and portability of a deceased spouse's unused exclusion amount, the DSU?
Thank you for that question. I would characterize a marital trust as simply a passing of assets straight to a surviving spouse, but in a controlled manner. So the deceased spouse gets to control what happens to this marital trust, but it's included in the survivor's estate, not the deceased spouse's estate. So basically, this is passing assets, whether it's outright or whether it's in a marital trust, it's passing assets to the survivor by way of the marital deduction, the unlimited marital deduction. So with that said, the relationship is that, generally speaking, not always, if someone dies and leaves all their assets to the marital share in a marital trust, they are basically saying, I am basically transferring all of these assets into my surviving spouse's side of the ledger, down to the surviving spouse's estate. And most of the time, not always, the deceased spouse has not used any of their exemption amount. So now, with all the assets in this side, now on the side of the surviving spouse, the surviving spouse is now going to choose portability, and they are going to port the deceased spouse's unused exemption amount to themselves, I should say, and they will have that amount, the amount that existed at the time of their deceased spouse's death, and they will still have whatever the amount they have at the time of their death. So the relationship is really pretty much this, that on Form 706, the federal estate tax return, the marital trust election, the Q-tip election is made on the Form 706, as is the dissous or the portability election. So both of those elections are made on the same tax return. So I think that's a relationship between the two. And the other relationship is simply that everything passes to the marital share, the ported amount comes over to the survivor, and that's the other relationship.
Okay, thank you. Could you please elaborate on what you meant about competition and fees between corporate trustees? You mentioned it'd be a good time to look at more than one potential corporate trustee.
Yes. The large institutions, Merrill Lynch's of the world, the broker dealers, the National Advisor Trust Company, which supports a lot of independent broker dealers, not all of them, but many of these large national conglomerates, they're looking to keep clients' assets under management. So let's pretend you have been working with a particular financial advisor. You really like this person. You want that person to continue to manage your assets, or that firm, and as long as that firm is in business. But you also want the benefits of a corporate trustee, the independence of that corporate trustee. Many of these broker dealers and other types of arrangements can be made where you can have that arrangement. You can maintain that relationship with your broker dealer and also have corporate trustee services at a very low fee. And remember, corporate trustees prepare tax returns. They basically have that independence rather than an interested trustee. So those kinds of arrangements are out there. Credit unions, such as Navy Federal Credit Union, have an independent trustee arm with low fees. So that's the kind of thing I'm talking about, is that broker dealers or large companies that are trying to keep client assets under management. Again, Merrill Lynch is one of those examples, plus others, many others. Those can be as low as 40 basis points, 0.4%, or even 50 basis points. These are very, very low trustee fees for corporate trustees.
Thank you. And last question for now. How do you choose when you have 10 youngish relatives, all of whom have about the same amount of ability to do this? I would like to remain or be impartial.
Well, that is just the greatest question. It's wonderful, first of all, that you have all of those choices. Yeah. I would say it's almost impossible not to be impartial in that circumstances, because you have so many. What I would say is consider that you can't appoint them all, even though you could. Consider that it just wouldn't be practical. I would think in terms of, do I want to appoint any of them as co-trustees, meaning that they have to act together? So I can get 2 of them as co-trustees, or maybe I just choose the top 5. I have successive trustees from the best choice I can make down to the 5th choice. But maybe you like the idea of co-trustees. So you have the number 1 person that you have at top of mind, and you say, well, as long as this person's alive, I want them to serve, but they have to serve with a co-trustee. And if this person can't serve, this other one can serve. So it could be that you could include several of them. But I think that the disadvantage of that is if you list too many, remember, all of them would have some standing to object or to bring an action if they disagreed with your trustee. So I'd say it's a counseling issue, but it sounds like you probably wouldn't want to name more than 3, 4, 5 of the 10, although you could name all of them. But that's a great problem to have.
It is. Okay, looks like those are all of our questions for now. If you have any final ones, please get them in right now. As we move forward with our webinar series to end the year, tomorrow we have Lindsay Moss, our senior principal and senior elder law attorney, talking about VA aid and attendance. That'll be at 10 o'clock tomorrow. After Thanksgiving on November 29th, we have Steve coming back to talk about what families need to know about planning for a loved one with special needs. And then on December 6th, kind of relative to this topic, we'll be talking about understanding the uses and purposes of irrevocable trusts. Then on December 8th, achieving perfection for your legacy, intentionalism in estate planning, a word that Steve used a few times today. And lastly, to round out the year, we're bringing back our wellness series, which I'm very excited about. We had 14 installments of that from late 2021 into the end of 2022. The Wellness Series, Thriving Through the Holidays, a celebration of gratitude with Dr. Michelle Fritsch, who's a wonderful friend of our firm. A lot of great insights and be a fun and insightful presentation. So looking forward to seeing you there. As a follow-up, I'll have our video and other resources to share with you. And I want to wish you a happy Thanksgiving. We can't do what we do here at Elville & Associates without you, and we're thankful and appreciative of your interest in Elville & Associates and being part of our webinar series. And we look forward to seeing you again soon. Any final comments, Steve?
Not at all, except happy Thanksgiving and holidays afterwards.
Likewise, we'll see you again soon. Thanks very much.